Good morning. This is the appointed time. We have a quorum. So let's start today's meeting, and that is meeting of the subcommittee on 3 pieces of subsidiary legislation relating to the implementation of a comprehensive smoking ban in construction sites. The first item is election of deputy chairman. We now proceed to the election of deputy chairman for the subcommittee on 3 pieces of subsidiary legislation relating to the comprehensive smoking ban in construction sites. The Secretariat earlier issued a notice in relation to the candidateship of deputy chair. Only one valid nomination has been received. The member so nominated is Professor Chairman Kwong, nominated by Ms. Rebecca Chan and seconded by myself. According to the House rules, members may decide whether we need to elect a deputy chair if we have received a valid nomination for the position. I see that members are all in agreement. So I now declare that Professor Chairman Kwong is returned deputy chair of the subcommittee. Thank you. Next item, meeting with the administration. Let's invite the administration to come in. This subcommittee will scrutinize 3 pieces of subsidiary legislation relating to the smoking ban. The first one will be scrutinized by or examined by positive vetting, and that is Construction Site Safety Amendment Regulation 2025, as well as 2 other items for negative vetting, and that is Smoking Public Health Ordinance Amendment of Schedule 2 Order 2026, as well as Fixed Penalty Smoking Offences Specification of Authorities in Public Offices Amendment Notice 2026. Members, I'd like to seek your views on whether we need to invite the public to provide written views or do it in another way. So will we be inviting views from the public, please? Mr. Dennis Lau. Chairman, since the construction site's landlord or the main contractor, the principal contractor may be involved, I'd like to give them an opportunity to add their views as well, especially in relation to disagreements on penalty levels. I hope that we can invite them to provide written views. Mr. Chow So Chung. Similar to what Dennis Long said, well, I think that the subsidiary legislation involves not only main contractors or principal contractors or subcontractors, even workers at the construction sites will be involved, especially if the construction sites are the outdoor. So we should invite the public in general and the relevant organizations to provide written views. Mr. Peter Shiu, I think apart from the major players, we need to gauge the views of workers because they are the real stakeholders. We should invite them to write in as well. Any other views? Ms. Rebecca Chan? Well, we can invite the Commissioner for Labor to elaborate on this point, because apart from collecting written views from stakeholders, the administration must have already reached out to different groups and collected feedback from them. I think it will be very important for our work if we receive such information as well. All right, a number of members have suggested inviting the public to provide written views, and it would be more appropriate if we collect their views in writing. So that's what we will do. We will send out invitations for written views. I believe many stakeholders, including trade associations in the construction industry, as well as members of the public, will be concerned. The Secretariat will put up a notice on the electrical website and inviting written views. The Secretariat will also send out invitations to the 18 district councils for written views. Now, for the submissions received, they will be forwarded to members. They will also be passed on to the administration. and the administration will provide a consolidated response in writing. So at this point, let me invite Mr. Sam Hui, Commissioner for Labour, to walk members through the 3 items of subsidiary legislation. I think we'll start a discussion on policy issues. Feel free to ask questions or make comments. If you want to speak, please press the button now. I will invite the Commissioner to very briefly go through the proposals. We have a big subcommittee. We are also joined by some members of the Council who are not subcommittee members who would like to give their views. So I'd like to save more time for the Q&A session. So over to you, Commissioner. Thank you, Chair, members. Good morning. I will very briefly go through the 3 pieces of subsidiary legislation as set out in the brief. I will explain the policy as well as the crux of the items. Currently, for construction sites in Hong Kong, in the indoor areas, smoking prohibition applies, whereas for outdoor areas of construction sites, there is no statutory smoking prohibition. So time and time again, we have heard of workers smoking in the outdoor areas of construction sites. As far as the law is concerned, we have the OSH legislation, and there are tools for us to assess risks in relation to different areas of construction sites, and that the Commissioner is empowered to introduce smoking prohibition in certain areas. The contractors in question will be obliged to enforce the requirement, and this is the established system, and this is based on the level of risks. Now, after the Wangfuk Court fire, there is now a high expectation from the public on regulating smoking in construction sites, especially since they may cause fire risk. And there is a need to shift from a risk-based approach to a comprehensive smoking ban in construction sites. And this is the basis of our proposal. In the past few months, we considered ways to amend the legislation so as to introduce a comprehensive smoking ban in construction sites. And that's what the electoral brief is about. The first proposal relates to designating the construction sites as non-smoking areas by amending the schedule of the Construction Site Safety Amendment. The Smoking Public Health Ordinance, and this will be made by the Health Bureau. Instead of gauging the level of risk in different areas of construction sites, the whole construction site will be designated a non-smoking area. And apart from designating the non-smoking area, or NSA, we understand that there are exemptions allowed in the current laws, including domestic premises or private quarters. They are exempted under the existing Smoking Public Health Ordinance. So, as we consider, construction sites may entail private domestic properties and private quarters. We need to strike a balance. Our proposal is as follows. We grant exemption to private domestic premises and private quarters so that these areas are not designated non-smoking areas, on the condition that those parts are occupied by the residents. So, for example, if the flat is under renovation and if the resident has moved out of the domestic property of the private quarters, then it will not be an exempt area. As you can see in our legislative proposal, we've considered the following. For subdivided units or flats that come with partitions, such as those to be regulated under the basic housing unit regime, there may be several residential units involved. And then there will be provisions to spell out the circumstances under which the area may be designated a non-smoking area or an exempt area. Now the next part is this. After designating an NSA, the penalties under the Smoking Public Health Ordinance automatically applies. There is no need to draw up a new set of penalties. In other words, it's a level fine 3 under the Summary Offences Ordinance. Offenders may pay $3,000 of fine in the form of a fixed penalty notice to absolve liability. And there is no need to amend the provision in this regard. However, in relation to specified authorities and public officers, we need to make an amendment, and that is a provision under the Fixed Penalty Smoking Offences Specification of Authorities and Public Officers Notice. Now, the amendment is not about the level of fine, rather is about the authority given to officers to enforce the law in construction sites. Basically, the enforcement action will not be undertaken by the Tobacco and Alcohol Control Office, but rather the occupational safety officers of the Labor Department, as well as the Commissioner for Labor, because we believe that the most optimal use of resources is to delegate OSH inspectors to enforce the smoking prohibition in construction sites. So the second proposal relates to enforcement and the authority of the enforcing officers. The third tool is about acts of smoking by individuals and how we draw a line in relation to liabilities, and that's about contractors and subcontractors. And as said in the beginning, we adopt a risk-based approach. We can designate certain areas of the construction site as a non-smoking area, and that when certain risks emerge, the Commissioner may specify that the area become an NSA, and that the person in charge of the construction site or person who has direct control over the construction site will need to observe this direction, failing which the person in question may be prosecuted. And after we introduce a comprehensive smoking ban in construction sites, we will streamline the arrangements, because we will no longer require the Commissioner for Labor to first designate a non-smoking area in the construction site. Rather, the whole construction site will become a non-smoking area. So, under the Construction Site Safety Amendment Regulation 2026, we are going to replace Section 53, and we will adopt a very simple concept. That is, for the person in charge of the construction site, the person will need to take all reasonable steps to prohibit anyone from using naked light to smoke or to carry specified smoking products. So it's a very clear responsibility. As for the level of penalties, we do not propose any further amendment. The court will have regard to the current Construction Site Safety Amendment Regulation. The maximum penalty stands at a fine of $400,000. Now, I've just explained the 3 pieces of subsidiary legislation. But in fact, the crux of our proposal targets acts of smoking by individuals in construction sites, as well as the management responsibility and consequences and the level of penalties for offenders. Now, for details, perhaps I'll just stop here, and then I will further elucidate when members raise questions. My team and myself will be happy to take questions from members. Thank you.
Thank you, Commissioner and the team. Let me read out the order in which members are going to speak. I understand that there are other meetings held in conference rooms, so this is for members' reference. Mr. Albert Chuang, Professor Chen Wing-Kwong, Mr. Chao Siu-chung, Mr. Aaron Bob, Mr. Dan Slung, Mr. Adrian Ho, Dr. Thomas So, Ms. Chen Ho Yan, Mr. Chris Ip, Mr. Augustine Wong, Mr. Xu Kafai, and myself. I'll assign a 4-minute time limit for now. Questions and answers included. Mr. Albert Chuang. Thank you, Chair. Implementing a comprehensive smoking ban in construction site is how we're learning from the experience of the tragedy of the Wangford Court fire, and the paper from the administration talked about this being a societal consensus. I think there's a need to amend relevant legislation. However, I still have some questions. 1. What is the definition of construction sites? We can see people constructing buildings. There are construction sites, and whenever there are AA works, the building department would categorize them into 3 categories. Would the sites be seen as construction sites? Would you delineate boundaries of construction sites for citizens or workers' reference? What I have in mind is if you have external works of a building, you would have the boundaries of the building set as the boundaries of a construction site, and we have people going by. And for example, a resident can smoke at home, but their family don't want them smoking at home, so they have to go to the rooftop or somewhere around the lobby to smoke. Would they be seen as breaching the relevant laws because they are smoking in a construction site? According to the paper, the proprietor and the employee may be prosecuted. Who is the proprietor? Is it the contractors, shareholders, or owner? Next, for occupational safety officers' powers, they now, with the amendments, have the power to issue fixed penalty notices. But how can we make sure they can effectively enforce the law? They will issue notices to those who are smoking or have smoked, but often there are disputes as to whether there is sufficient evidence. The individuals have to be caught in action unless they have photos as evidence. Would the administration make use of technology to help with enforcement? Thank you. Commissioner for Labor. Thank you. In fact, the definition of construction site is really clear. There is a specific definition in occupational and safety and health related legislation. I will not repeat the definition here, but the concept is where there are construction works being undertaken, it will be regarded as a construction site. Mr. Chuang asked about some construction sites that are open air or there are indoor sites that are undertaking alteration works or works undertaken within domestic premises. As long as works are going on, it will be regarded as a construction site. For the larger construction sites, there are works being undertaken, and at the accesses to construction sites or where they pile construction materials or where they load or unload construction materials, they are also included in the site area of construction sites. It is clear in law. In actual operation, for larger works or larger construction sites, there are accesses for the public. So there is some sort of overlap of where citizens live and where works are being undertaken. This is what we considered in our design. We want to prevent people from inadvertently breaking the law by entering the no smoking area in construction site and smoke there. So construction sites, we would have in future ask for contractors to have adequate signage so that not only workers but general public will know the particular area is within the boundaries of a construction site. And management personnel of the construction site has to take reasonable steps to do that. For the proprietor, it would include the different contractors as long as they have management responsibility towards the construction sites. In enforcement, it may be hard to catch an individual who is smoking at that very moment. But once we have designated construction sites as no smoking areas, any form of record, as we saw before, we had citizens taking photos of construction workers, and as long as we can identify the smoking individuals and where they smoked was a construction site, it would be good enough for enforcement. And we would also make sure during inspections at construction sites to see if management personnel of construction sites issued appropriate reminders to workers to not to smoke, as well as whether there are a large number of discarded cigarette butts in the construction site. If so, we'll take follow-up action and enforcement. Thank you. Professor Chen Wing-Kwong, Deputy Chairman. Thank you, Chair. I support implementing a comprehensive smoking ban in construction sites. Not only does it lower the fire risk, it also reduces the impact on health of construction workers. I have some concerns about the amendment proposals, however. If people breach the law by smoking in construction sites, they will be fined $3,000. And for contractors, if they breach the amended Regulation 53, if they're convicted by the court, the maximum fine is $400,000. If someone inadvertently breaches the law, if someone breaches the law by smoking and causes a fire, the one who should be held culpable is the smoking individual, not the contractor. So why has the administration set the maximum penalty at the level of $400,000? What are your justifications? What are your references? I do not object to the amended Regulation 53 asking for contractors to take reasonable steps to prevent people from smoking. But what is the definition of reasonable steps? There may be different definitions, it can be confusing for contractors or the general public. Would the administration consider setting out a schedule or guidelines to clearly set out what the major reasonable steps are for the compliance of contractors and to facilitate enforcement? The commissioner said if there is adequate signage, it is already seen as having taken reasonable steps. But I want to ask, has the administration assessed with the taking of reasonable steps how much in manpower costs or other costs would it impose on the contractors? And is it the case that with no smoking signage, people will not smoke in construction sites? We also have in the amendment proposal specification of occupational safety officers taking enforcement action against smoking in construction sites. I appreciate and support this, but before relevant enforcement work is undertaken by TACO, and the relevant enforcement personnel would undertake comprehensive training in this regard. They also undertake training given by the police force. Would the administration provide relevant training to occupational safety officers to make sure they have the capabilities and flexibility to undertake relevant enforcement work? Commissioner, thank you. In terms of penalties, under the construction site safety regulations, contractors have different responsibilities in implementing actions to fulfill their responsibility. And the penalties are generally at a similar level. And in 2023, the Legis passed relevant amendment proposals to increase penalties in relation to occupational safety and health. Then, we did not make amendments on this occasion on relevant penalties. We do believe there is individual responsibility when they smoke and causes a fire, but then ultimately the person in charge has management responsibility. Why haven't they dealt with the risk of someone smoking in construction sites? On the member's second question, the person in charge needs to take reasonable steps. They can put in signage, but putting in signage alone is not enough. In our private exchanges with contractors, stakeholders have raised several suggestions on effective measures. For example, prohibiting workers from bringing lighters and cigarettes into construction sites. Before workers enter construction sites, there will be management measures such as asking workers to leave their personal belongings. Site personnel would also have to conduct inspections, and they may also have to make adjustments to the cameras installed at construction sites. In daily management of sites, if they find workers to be non-compliant as part of management, they will need to take reasonable steps to educate the workers, deal with them administratively, or make referrals to the Labor Department for enforcement. These are seen as reasonable steps. As for whether we can set out guidelines so that contractors can just follow them, I think this is challenging because, as Mr. Albertron asked and I answered, for construction sites there are different scales and they are quite different in nature sometimes. It depends on what works are going on, how the sites are managed, and which part of the project they are working on. We will work with the sector to establish different scenarios, what the reasonable steps are and what effective actions are and they should take. I don't think it is the most effective approach to set out everything in a document. But we keep an open mind. After implementation of relevant legislation, once we have established with the sector some best practices that can be of reference to the rest of the sector, we can promulgate a document. We do not rule out this possibility. Lastly, on training work, we have already been providing training to our officers. We have also invited TACO officers to share their enforcement experience with our officers. They have had exchanges, and in terms of enforcement, in future, TACO and other public officers would have enforcement powers. We will work with them in future. Thank you.
多謝主席。
Mr. Zhao Shouchong. For the safety of workers as well as members of the public and for public health, I fully support introducing a comprehensive smoking ban in construction sites, but I have a number of questions relating to your policy. Now, for contractors with means, if they voluntarily set up non-smoking areas in big construction sites, then why shouldn't they deserve an exemption? Because as I understand, some major contractors do have very stringent rules imposed in big construction sites. And if a worker is found to be smoking, the worker will be dismissed on the spot. Still, some workers may continue to hide and smoke in less conspicuous places, and very often receive complaints from the public about workers smoking right outside the construction sites, at the mostly at the passageways of pedestrians, and that's the usual complaint, is a nuisance. So if contractors set up set up a special area for for workers to smoke in construction sites in a safe manner, then why can't it be exempted? Because you have an exempt area in your regulation anyway. The next point is about the definition of construction site. For hospitals, schools, parks, we can just check the law and very easily we'll know if it's a non-smoking area or not. But what about, say, at a construction site where repair works are being carried out? There is a truss-out scaffolding on the exterior wall. Then if I happen to walk past that scaffolding, then on the ground floor, is it still a non-smoking area? Shouldn't that be clear signage? And for the definition of construction sites, one of the components is where construction materials are stored in the vicinity. What exactly is meant by that? What is meant by construction materials? Let me give you a very simple example. Say if there are scaffolding works being carried out on the ground, there may be canvas placed there for days. Are they regarded as construction materials? Is there any signage? If I walk past and if I happen to be smoking there, will I be breaking the law? And also, do you have definition as for the distance away from the materials defined in order to smoke without breaking the law? The third question is about responsibility of contractors and all reasonable steps. Mr. Charles Chung, you should save some time for the administration to answer your questions. I want to know more about requiring contractors to take all reasonable steps within the construction site. Commissioner. Now, the member asked several questions. I think it's a matter of principle. We need to share this with members. The policy objective of the comprehensive smoking ban in construction sites is not just to facilitate enforcement, but to drive a shift in the work culture in construction sites. In fact, this norm in Hong Kong for people not to smoke in workplaces. For some individual sectors and industries, for various reasons, some workers do need to bear the smoking habits of their co-workers. They may not be smokers, but they need to tolerate the secondhand smoke because of their co-workers smoking. So we'd like to take this opportunity to drive the shift in culture in construction sites. And to answer Mr. Chow's question, why is it that we do not allow contractors to set up a specified smoking areas within a construction site? As Mr. Chow mentioned, this is exactly because of the public backlash after the Wangford Court fire. There is great resentment for workers who are habitual smokers. We don't want to give them any message that smoking is still allowed in construction sites as long as you follow the rules, because this will create gray areas which will pose difficulties in enforcement. We don't want to send this message to workers. So for site managers, it will be very difficult to control the workers. That is, should we define the area of specified smoking areas, and if you smoke some distance away from the smoking area, will you be breaching the law? That is why we want to take a harsher approach and adopt this very clear concept that no smoking should be allowed in construction sites unless it's an occupied private property. We want workers to build a new habit, and that if you want to smoke, you need to leave the construction site first. We want to foster this culture, and once this happens, we will further fine-tune our specific measures to see if, for example, for bigger construction sites, there may be conditions for allowing smoking areas to be set up. Just very quickly on dissemination of information. Well, very quickly, can you explain about public education and storage of materials? Well, I think in general, it's a nuisance for smokers to smoke in the street, in the minds of non-smokers, of course, and it's not against the law. Now, if you walk past a construction site or if you walk past a set of scaffoldings, then if you smoke, in some ways, you're posing a risk, especially if you just discard the cigarette butt there. It's a risky behavior. So the member asked about the safe distance for somebody to smoke. Then apparently if you go out and if you're close to a construction site or a place with works being carried out or with the presence of scaffolding, then please just stamp out your cigarette before you go near that area. And I'd like to take this opportunity to ask this question. You explain why the government will not allow contractors to set up legitimate smoking areas within the construction site. I appreciate that. But in private quarters, there is exempt area for residents to smoke. So what if in the private domestic property, the workers are invited to go there and smoke and enjoy themselves? Then it's not against the law. Then in a way, wouldn't this private domestic property become the de facto lawful smoking area? Is there a way to handle this situation? Let me explain the concept for clarification. In a construction site, including private domestic properties and private quarters, the act of smoking by an individual may be exempted in some circumstances. However, for the person responsible for managing the site, reasonable steps should be taken to ensure that nobody smokes in the construction site. So if the quarters involved are temporary structure set up within the construction site, then basically the quarters are set up for the purpose of works being carried out there. And basically the quarters are inhabited by employees or the managerial staff of the site, then the manager will still be responsible for ensuring that there is no smoking going on. The so-called private quarters where workers stay should not all of a sudden become a smoking lounge. They'll be subject to prosecution and investigation. Right, so the contractor will still be responsible. I just want to make sure that as far as the law is concerned, the private quarters will not become a lawful smoking area. I hope that there will be a distinction as far as the law is concerned. Please follow up on this matter, Mr. Aaron Bock. I definitely support the comprehensive smoking ban in construction sites in response to needs and calls from the community. But then we're talking about enacting legislation, and we need to exercise prudence to avoid causing nuisance to the public. Now you issued a paper to Legis dated the 4th of June, and then for item 6, you refer to the definition of construction sites, and that relates to RMAA, and then for specified structures and works, etc., any water, electrical, gas, telephonic works, etc. And then you also refer to what was raised in the question, and that is for works carried out that are common home improvement projects, then it will still fall within the definition. Say if I have water leakage problem at home, I ask a worker to come help repair, and then for the smoking offense, I, as the employer, will be fined $400,000. That's 133 times the fine imposed on the smoker himself. That's $3,000 fine. So we need to be very careful. We don't want to casually pass the legislation and then be criticized for not being careful enough in the examination process. So we need to be very careful about the definition of construction site so that nobody will be entrapped. Now my next question relates to construction companies. The employer will be fined $400,000, and then he'll be fined under the Factory and Industrial Undertakings Ordinance. Now, the Development Bureau is in charge of appraising the performance of contractors. If the contractor is found to be in breach of the Factory and Industrial Undertakings Ordinance and be fined $400,000, this will affect the appraisal report, and there'll be a slimmer chance for the contractor to win the bid.
Commissioner, thank you. Mr. Bach's example is a good example. Let me also use that example to talk about how it works in law. For citizens, hiring workers to do some simple decoration works, for example, fixing pipes, doing works on the window, air conditioning works, or some kitchen works. If citizens never left the domestic premises and stayed in other domestic premises. Well, I think for most simple works, they would or still be residing in the relevant premises. This would become an exempt area instead of a designated no smoking area. For citizens purchasing services of workers, they are not seen as proprietors under relevant occupational safety and health legislation. So the liability that would have a maximum penalty of a $400,000 fine, they are not imposed on citizens procuring relevant services. The relevant liability will only be imposed on management personnel of contractors managing the relevant workers. So basically, when there is a failure to fulfill such responsibility, the persons in charge of contractors will be proprietors. The scenario raised by Mr. Buck, the relevant laws will not be applicable. We have some maintenance works undertaking at home when there is domestic activity. It is not applicable. Excuse me, so basically it is about whether the citizens are staying there. And if the citizens have left for 2 weeks, will it be seen as a construction site? It is a construction site. Will the citizens have a responsibility then? Citizens won't have responsibility in this regard because the contractors are managing the site. So those who are responsible in that contractor would be fined. I believe these are already in the provisions, but we may have other members asking about questions on domestic premises. So perhaps we can continue with this reply when other members ask about this. Mr. Dennis Lang. Thank you, Chair. With the provisions, there are often jargons that are hard for citizens to understand. So can you have some sort of publicity materials to talk about which scenario in which the relevant laws are applicable, which are not, which are no smoking areas, which are exempt areas? I also have some concerns about Chapter 59I. You would remove the existing definition of flammable products as long as one is smoking. That would already be regarded as a breach. But why do you need to remove the part for flammable substances? Why can't we have both? When people smoke, they may also be indicted. Specifically, the contractor or the proprietor may be indicted. But if they can't really stop people from smoking, sometimes they can't really be held accountable. So is there some sort of a summary conviction mechanism, just like what we have for mandatory reporting of child abuse ordinance? Thirdly, on inspection, it is said that the administration would adopt a risk-based approach for inspections. For some construction sites, they only do short-term works. How would you assess the risk? And you said that the inspections would be undertaken regularly. What is the specific frequency do you have adequate manpower in the Labor Department to make sure you fulfill your end of the work after implementation of the relevant amendment proposals? Commissioner, thank you. We do accept that we need to do more publicity work after implementation of relevant amendment proposals for contractors, workers, as well as the general public. They need to understand, especially for citizens, when they get close to construction sites, if they are smoking, they should be aware of the relevant laws. As for construction site safety regulation, as we have a comprehensive smoking ban regardless of the risk, we do not consider it necessary to specify flammable substances. But then within construction sites, there are different fire risks depending on the procedures being undertaken and the relevant materials. Let me say this, with relevant laws banning smoking is just one of the things in the toolkit that we have to enforce against occupational safety and health related offenses. If one exposes themselves and others to hazards, we do have some general provisions to initiate prosecution on. And when we consider this option, it's not against general smoking acts. It is when one smokes in a dangerous environment or they make use of naked lights in an appropriate setting, when the nature is relatively serious, then we may indict relevant individuals. As Mr. Leung said earlier, we do have a two-tiered regime. We do have summary convictions. We also have indictable offenses. There are two approaches. They have different penalties because their seriousness is different. We do already have a toolkit for offenses of different degrees of seriousness. Thank you. For the first few questions, I have been relatively lax in enforcing the time limit because members would want to see what the administration's stance is. When there are points that are repeated in future, I will ask members to be succinct. Thank you. Mr. Adrian Ho, I very much support the proposals. I think there is great hazard with one smoking in construction sites. However, I have some questions. For the fixed penalty, it is $3,000. I think smoking in construction sites is actually more serious than other locations, so $3,000 is not enough. Also, I want to ask if you can raise the penalty without it being too high at a level which people think is unreasonable. Next, I can see that with the government's approach to have a comprehensive smoking ban, it seems to be half-baked. If people possess irrelevant products, there is a possibility of them smoking. You take enforcement action. There is therefore greater efficiency in enforcement. It is also said we have occupational safety officers enforcing relevant laws. There are exemptions. There are no smoking areas. There are other officers that may take enforcement work. I think the overall principle is not to have people smoke at all in construction sites. Why not just take a more clear-cut approach so that people won't exploit the gray areas? They would probably say, oh, this is an exempt area, so I'll smoke here. I also want to say we can encourage construction workers to quit smoking on a large scale. We can just hand out those nicotine candies to construction workers to encourage them to quit smoking. Why not just have a large-scale operation to encourage them to quit smoking? I think this can, in the end, enhance your enforcement efficiency. Thank you. Commissioner. Thank you. We have received differing opinions on the $3,000 figure. At the beginning of this year, as the member may remember, we have proposed a penalty of $150,000, and there was an outcry because they thought smoking and being fined $150,000, that's a lot. Now we think setting the penalty at $3,000 is striking a balance for workers. If they smoke, they will be fined $3,000. We also have penalties for management personnel of construction sites. The fine is not low for contractors. On the subject of deterrence, we keep an open mind. If we think $3,000 is not deterrent enough, we can make adjustments whenever necessary. We just need to first establish a regime where we say very clearly smoking is illegal. As for exempt areas, I think the member can rest assured because we have a very narrow definition of exempt areas. It is only for occupied domestic premises. We have people smoking in their homes or people lighting incense in their homes. If they have workers doing work in their homes, but they are still living in the relevant premises, would it affect citizens in a way that they can no longer smoke in their homes? We have chosen to strike a balance between private property rights and personal freedom, as well as occupational safety and health risks. For those living in the premises, smoking in their homes would be exempt. There are no other exemptions for construction sites. So if one is clear about this, people should understand they won't be entering an exempt area and then a non-exempt area just through walking in, say, different rooms. I would also say, as Mr. Adrian Ho said, the best way is to lower the proportion of smoking workers. It is safer. It is also good for their health. We are working with the Department of Health on this. In future, we will have anti-smoking enforcement operations. We also will provide support for workers to quit smoking so that workers can work safely and that they can live heavily. All right, Dr. Thomas So.
Mr. Thomas So. Thank you, Chairman. Let me make it clear that I fully support the comprehensive ban in construction sites. And I've read all the papers, including the paper issued by the Labour Department in response to the questions raised by the Legis Secretariat. The crux of the legislative proposal is to introduce a smoking ban in construction sites, but I see that there is reference to different pieces of legislation involving non-smoking areas and also designated exempt areas. And that explains the concept of so-called exempt areas in construction sites. Now, I think that the objective of the proposed amendment is to tackle the relevant offences, and that is for people to smoke or light cigarettes in construction sites, and these are acts that would pose a fire risk. We also want to regulate those managing the sites and those in charge of the sites, or those who have direct control over the sites. Now, members asked about the definition of construction sites, and I fully agree that we need to define what a construction site means. Say, perhaps we can rely on the building plans already issued so that we can then regulate the acts happening in the construction site. And then let me refer to the reply given to the Electrical Secretariat. I think it's rather complex, especially in relation to issues 11 and 12, when you explained under what circumstances will exemption apply, and that relates to whether the premises are occupied and whether the area in question is under renovation. And for the so-called front shop back home, the shop portion will fall outside the definition of domestic premises and not qualify for the exemption. Now, I think you're just answering the question on the point of law. I have no question on this. But then, since the proposed amendment will change the liability of different parties, then we need to make sure, for example, which part of the construction site is regarded an exempt area, because this would directly affect the liability of different individuals. As a commoner, I may not understand whether this is permitted by the law or not. So perhaps you should go back and give it a thought. Like Mr. Adrian Ho just now said, perhaps you should introduce a comprehensive ban in construction sites more directly. Well, so please give time for the Commissioner to respond to you. So still on the point of exempt area, there may be new liabilities arising from the proposed amendments. You need to be clear. Right, I think the question is clear. It's about whether the premises are occupied or not. Now I'll try to explain in plain language. When it comes to exemption, the law may capture different scenarios, but from the perspective of the general public, it's either one or two. One, if we're talking about domestic premises, then a workman may be carrying out works in the indoor areas of the premises, or on the exterior wall of that flat there may be scaffoldings and works are being carried out there. We want to make sure that if the resident smokes in their own home, they won't be breaching the law as a result, because this is something that they normally do at home. So that's a kind of exemption. There is no provision that puts liability on the resident who lives in their own domestic property where works are being carried out. So that's the first thing. Second point, Now, as far as the responsibility of the contractor is concerned, where works are being carried out on domestic property which is occupied by a resident, then regardless of whether the premises are occupied, for home renovation projects, the contractor in question will have the responsibility to make sure that no worker smokes on the premises. So that's the manager's responsibility. The manager will be required to take all reasonable steps to stem out that risk, or else there'll be legal consequences. So for the general public, let me reassure them. It's not really difficult to understand this concept of an exempt area in the domestic property which may be regarded as a construction site if there is renovation going on. As we explained in our reply to the Legislative Council Secretariat, we want to elucidate the legal concepts and the use of terms, but in fact, in general, this concept is quite easy to understand. Well, I think Mr. So's question is this. You cited some examples in your response to the legal advisor's questions, and that if you explain if you are a resident, you shouldn't have to worry. But then, let's take a look at issue 16 here. Say, if this owner does not live there, and if the flat is being renovated, then if the owner goes there temporarily to check the progress, and if the owner smokes, then this owner might be breaching the law. In fact, residents may go back and check the progress of renovation, but they are not going to set up a temporary bed and claim to be living there. So even if this owner owns the property, then there may still be a chance of breaking the law under the proposed amendment. Ms. Rebecca Chan, I support a comprehensive smoking ban in construction sites. But I think the government should be careful in ironing out the implementation details. Now we're joined by the Labour Department here. I hope you'll be able to answer the questions on tobacco control and smoking cessation. Now, as far as the current Smoking Public Health Ordinance is concerned, the law enforcement officer will need to so-called catch the smoker red-handed before a ticket can be issued. But very often when I go to the back staircase and find somebody smoking, and even if I make a complaint, the smoker may then go on with chain smoking. They smoke one after another, and 3 cigarettes on. No enforcement officer may be found, and it's very difficult to prosecute them. And that in the construction site, it may be even difficult for an OSH officer or inspector to do so. In fact, in recent months, I think we have seen footages of workers smoking at the construction site after Wangford Court fire, and that the relevant footages are not admissible as evidence, so it's very difficult to initiate prosecution. After introducing the comprehensive smoking ban, if you receive complaints about these footages, how are you going to follow up on them? Can they be admitted as evidence, or will you just pass on the clips to the contractors for direct action? The third point is that we need to be concerned about the workers, right? Because they may be dismissed on the spot if they are found smoking. Then we need to consider if on-spot dismissal is the prevailing practice, then will there be pressure on the contractors because we already have penalties available under the legislation. The next point is about smoking cessation. We want smokers to kick the habit. Now, has the government conducted any surveys about the smoking prevalence rate among construction workers? Because I've talked to many NGOs, and many construction workers do have an intention to quit smoking. Introducing the smoking ban is one thing. If you want to control risk, you should address the problem at source and help them kick the habit. So do you have any figures in relation to referrals to smoking cessation services? Will there be a need for additional resources to help workers quit smoking? Because many of them are chronic smokers. Apart from this proposed amendment, you should think of ways to help them quit smoking. Commissioner. Ms. Chan asked whether the offender must be caught red-handed before a fixed penalty ticket can be issued. That's not the case. In fact, it boils down to the offender's capacity, the location, and whether the threshold for enforcement action can be met. If there is sufficient corroborative evidence shown in the clip or the picture in question, for example, under the current laws, apparently it's in a construction site and we have no doubt about the identity of the person, and the clip also directly captures the act of smoking, then even if it's indirect evidence, there will be sufficient ground for us to issue a ticket and initiate prosecution. We don't need to do it face to face. As long as we know the identity of the person, there will still be a way to issue the ticket to the offender and initiate the prosecution procedure. This is similar to traffic offences. The vehicle's license plate may be captured or a footage may be provided by a pedestrian, and then the police may take enforcement action. Now, Ms. Chan also referred to the Tobacco and Alcohol Control Office, and that there are difficulties for officers to enforce the law. There may be enforcement difficulties in relation to receiving a complaint and not being able to identify the offenders in question. But when it comes to a construction site, the person in charge of the construction site will be able to give us information about the location of workers and the identity. So, in the future, prosecution may be initiated by using indirect evidence. We believe the contractors in question will take up managerial responsibility and help us prosecute the non-compliant or offending workers. Now, is it that the non-compliant worker must be dismissed on the spot? I think we need to have regard to the specific circumstances. For example, whether the worker is blatantly disregarding the risks, or is it just a matter of habit and lapse of judgment? I think the management will need to have regard to the circumstances. And I think most contractors will not just frequently dismiss their workers. We have the same pool of construction workers, in fact, and there is competition. I'm sure that they will exercise good employment relations management as well. For smoking cessation, we need to coordinate with the relevant departments, such as the Health Bureau and the Department of Health. They offer smoking cessation advice and services. Together with the Primary Healthcare Commission and the CIC, we introduce collaboration measures so as to offer smoking cessation services to workers in need. And we agree that if they're able to kick the habit, we'll be able to fully address the safety and health risks as arising from smoking. We'll continue to work with other government departments. Chairman. Yes, Ms. Chen, let's see whether this subcommittee can follow up on the matter. Well, we're talking about resources. Apart from the legislative proposal, since the Commissioner mentioned collaborating with other government departments, we're not joined by the Health Bureau today. We need to know, for example, how much money will be devoted to this area and whether there'll be outreach teams to help workers. I think we need a written reply from them. It involves a policy issue. Right, on smoking cessation and referred by the Labour Department, please do tell members what your plan is.
Next, Mr. Chris Ip. Thank you, Chair. I believe other members know I very much support the government in implementing a smoking ban. I also support the amendments proposed by the administration on this occasion, but I have some clarifications to make. The Commissioner talked about a case where there are construction materials piled up in construction sites, and the general public and workers, of course, won't smoke in those areas because it is very obvious. But for example, if we have construction materials piled up on Nathan Road and people must go past the relevant road section, I think it's not a matter of discipline. I think if there is no clear explanation, people may inadvertently breach the law. So I hope the administration will clarify this so that citizens will not inadvertently breach the law. After the amendments come into operation, we will have occupational safety officers taking forward relevant inspection and enforcement work. Do you have adequate manpower? Because there are quite a number of construction sites in Hong Kong. Can the occupation safety officers do random inspections to really stamp out the problem? For contractors, they have a responsibility to make sure people don't smoke. If someone smokes, they will be fined $400,000. So let me give you an example for a housing estate that is undergoing major repairs. And if a worker goes to the ground floor and starts smoking, the contractor is penalized as a result. Can we have the relevant provisions punish workers as well? If we put all the responsibility on contractors, I think this is too strict. I want to hear from the Commissioner what he thinks about this. Commissioner, I think people are unlikely to inadvertently breach the law because where construction materials are and the accesses are often managed by site personnel. Excuse me, Commissioner. Let me be specific. For, say, Nathan Road, there won't be people telling you that this is a construction site. They won't be deploying officers outside the site. There will be materials piled up. They will not block the relevant road section. I think what Mr. Yip is saying is the Labour Department is clear about the definition of construction sites, but the public may not be as familiar. So if the contractor has to take reasonable steps for clear signage, or whether they need to enclose the site. Commissioner, for the contractor, they must put in place appropriate signage. They have management responsibility. If we go past Nathan Road, there may be bamboo scaffoldings. Unless the citizens go up to the bamboo scaffoldings in enforcement, it is unlikely that we are going to say they have entered the construction site. But then there are bamboo scaffolds on the ground. Wouldn't that be seen as part of a construction site? I think what Mr. Ip is saying is when the works are being undertaken on an upper level, the bamboo scaffolds are temporarily placed on the ground level. And I would say this would not be regarded as where construction materials are being loaded, unloaded, or managed. It is actually quite clear where construction materials are placed, and this is seen as part of the site being managed by the contractor. So when there are no works going on, but where construction materials are being processed, loaded, or unloaded, if one puts construction equipment on the floor or on the ground, it does not make that particular area a no smoking area automatically. That's what I want to say. We try to deal with different risks, fire risks, especially that related to smoking. We will conduct inspections. But when we conduct inspections, it's not just for the issuance of fixed penalty notices against smoking. We will look at different things, whether there is proper management, whether they have implemented safety measures, whether they have taken reasonable steps to mitigate relevant risks against workers smoking, for example. We are not tackle. We comprehensively enforce against breaches of occupational safety and health legislation. It's already part of our work. It's just that there is another item we need to pay attention to. We will make good use of our existing manpower for relevant operations. But if we need to make adjustments in response to the overall demand for occupational safety and health enforcement in construction sites, we will strive for Legis support. Mr. Augustine Wong, thank you, Chair. I'm not a member of the subcommittee, but I thank the chairman for allowing me to speak here. I think the Labor Department and the Department of Justice have to be prudent. They try to give an exhaustive list, but then when we have different things in mind, contractors may be subject to excessive risk. So I ask them to be really prudent. For exam areas for occupied domestic premises, say for subdivided units or basic housing units, if one is occupying a particular unit and the other unit is undertaking decoration works, would the whole premises be seen as a construction site? I think there are some restrictions with exemption if people may be punished. So I think you should make clear what happens. Like Mr. Chao Su-chung, we don't want workers to smoke for their health. But then for large projects, for example, the one in the Loop, we have a site that is hundreds of thousands of square feet in size. It is really hard to make sure workers don't smoke in the sites. Can we have some sort of exemption to provide for special cases like this? We do not support smoking, but we do understand for some workers they need to smoke. I want to ask for open air works, excavation works that do not involve dangerous goods. there is not much risk, would you consider providing exemption for this as well? Commissioner. Thank you. As I said earlier, it is very hard to spell out all reasonable steps that should be taken, but we had previous communication with stakeholders as to what steps are reasonable. In different cases, they may be different. In the sector's discussions, there are already some suggested measures, but there is no list as to what all the steps are that should be taken to be seen as reasonable. It is still on a case-by-case basis, but I think with more experience, we will be able to establish some principles. Say for the management measures, what basic items there are for one to be seen as having taken reasonable steps. Generally, I think there will be a consensus. For basic housing units, if a flat is separated into two basic housing units, say basic housing unit A and basic housing unit B, if one of the units is undertaking decoration works, and if one is still living in that unit, that it would become an exempt area. It wouldn't be because there are still people occupying another unit. If one is not staying in the unit undertaking alteration works, that the area would be regarded as an exempt area. Yes, Mr. Augustine Wong. If the chairman will allow it, I want to follow up on something. Please be brief. I have no objections to what they said, but I think we shouldn't say all. They can just say reasonable steps to be taken. If you say all reasonable steps, that is wide coverage, and contractors are likely to inadvertently breach the law. For basic housing units, each basic housing unit is not seen as premises. I want to ask if the exemption only applies to people where people do not occupy. The latter. Thank you. Well, you can perhaps review what the member said as well. His other comments, Mr. Shukafai. Thank you. Many people suspect the Wentworth Court fire was caused by smoking, and we have had citizens feeling uneasy and therefore took videos of workers smoking on scaffoldings. I do support the general directions for the legislative amendments, but as some other members said, we want to make sure with the amendment proposals prevent smoking from causing fires instead of asking construction workers to smoke less, because this is actually under the purview of the Health Bureau. As another member said, if we are to invite Health Bureau representatives like the member suggested, we need to involve many different departments because the relevant work concerns different bureaus because we're trying to prevent fires. Some other members talk about the larger construction sites spanning across 100,000 square feet. it is indeed hard to catch workers who are smoking. We have talked about different options, designating some smoking areas within construction sites and whatnot. And I think with those who are smoking at homes, you can't really do anything. And if those are quarters, as the chairman mentioned, you can't really stop them from smoking. But I think for workers, they may have temporary accommodation. Can they go back to sleep during daytime? And if they can perhaps smoke there, and they can probably have their other friends go there and smoke as well. If you need to prevent that from happening, you need to amend more laws. You need to prohibit perhaps them from inviting their friends. What I'm saying is many people will just be thinking about how they can smoke. So I think we really need to strike a balance. We want to make sure we won't have fire caused by smoking. If we have steel scaffoldings, would that resolve the issue altogether? I think it is also important that we do not have flammable substances in construction sites. Even if you have a cigarette butt, if it's just steel, it won't cause a fire. I think you should really think about that, because 30 to 40% of the workers smoke. If we prohibit people from smoking, it can really cause a decline in supply of workers. Thank you.
Any response from the Commissioner? Apart from the design of the laws, we also need to consider the enforcement aspect. It's a risk-based approach. So for Mr. Peter Shill's point, I think that we do have regard to that in the actual implementation. Now, for managers of super sites, we will further discuss with them to see how we strike a balance. Ms. Christine Fong. Thank you, Chairman. The Wangfuk Court fire happened, causing casualties, and even construction workers died in the fire. So I fully support this proposal. We need to introduce a comprehensive smoking ban in construction sites. This is a very serious topic. I support this proposal. That's the first point. Second point, there are many construction sites in Hong Kong. Now, members just ask questions on its definition. So here is my question for Mr. Hui, the Commissioner. In future, will you require construction sites to come with clear signage telling people that it's a construction site? Because some members talked about bamboo scaffold or tubular platforms occupying the pavement areas. So it's quite ambiguous whether it forms part of the construction sites. I think the matter can be addressed if you ask for signages to be put up. And then in paragraph 14 of the paper, you mentioned non-smoking workers being affected by the secondhand smoke. Now, it has come to my attention that quite a lot of construction workers would smoke right outside the entrance of the site or other places. Say, for my constituency, there is a housing estate undergoing renovation, and then workers will go to the other block where there is no renovation and smoke there. And I think there should not be any smoking area permitted on construction site. But then this will lead to the problem that I mentioned. Say, will you consider something like smoking lounges in Japan? You can allow for contractors to apply to set up such lounges, because say I've come across a housing estate, the entrance of which has a tree, and then there is a so-called a cigarette butt collection box there, and it comes with white fumes all the time. Even the tree is damaged as a result. And about the unoccupied domestic property, I still don't understand when it comes to a major renovation project not involving the whole building but just a flat. Is there any definition on whether it's occupied or not? Because the renovation may go on for a year or two, and that there may be workers smoking inside, and that the neighbors may be concerned about the fire risk. The owner may not live in that flat, but still neighbors are concerned. Right, Ms. Fong, please focus on the last question, because for the definition of construction site, I think the Commissioner has already answered a number of times. Now, about the housing estate with major renovation going on, that depends on the scale. Sometimes the works may be carried out in a particular block. So the boundary of a construction site changes all the time depending on the progress. But then the concept is clear. If the residential unit is not inhabited, then no smoking is allowed. About the boundary of construction sites and signage and tobacco control policy put in place by the managers, we have been discussing with the construction sector, and we will do more to make sure that workers will not be driven out to smoke outside the sites and cause other problems in the community. This will be done through the giving of advice. Next, Mr. Jonathan Leung. Thank you, Chair. I'm not a member of the subcommittee, so I thank Chairman for allowing me to speak here. My first question is this. We have been discussing this issue for a long time. Do you have any rough estimate as to smokers on construction sites? Just give me a ballpark figure, because we just discussed smoking cessation, but I want to know exactly whether there are many construction workers smoking in construction sites. Now, I support the legislative amendments, but even after introducing the comprehensive smoking ban in construction sites, our workers who smoke will continue to do so. They will just smoke outside, and there are narrow passageways outside the construction sites plied by children. And that, how do we address the problem? And about bigger construction sites, it's very difficult to leave the site, take a break and smoke there. And if they try to smoke in a construction site, it's against the law. So how do you address this problem? Third question, in relation to private quarters. Will all construction sites come with private quarters in the future, so as to allow workers to smoke there? And do you have definition on, say, the provision of beds in private quarters? Now, some of the questions have been answered, so I will skip those. You ask about private quarters, and that is the accommodation provided by the employers for handling temporary works procedures, and whether it's regarded as private quarters. Now, perhaps at the clause-by-clause scrutiny stage, I will further elucidate this point. About construction workers who smoke, According to the industry's estimate, about 3/4 of the construction workforce smoke. How many workers are willing to quit smoking? Now, I'm afraid we do not have the figures. But we learn from the smoking cessation service providers and other health care institutions that in recent months, the number of workers approaching them for smoking cessation services have surged substantially. So we need to consider both. Workers may work in construction sites in different circumstances. Is it necessary to arrange for an area to be designated as smoking area? I think that we need to send a very clear message as far as the law is concerned. Smoking is a personal choice, is not a worker's right. So we need to strike a balance between managing risks at construction sites and allowing personal freedom to make a choice. So that's the first step. And frankly, in the future, as to whether we need to fine-tune the proposal and introduce special measures or introduce tailor-made measures for mega construction sites, I think these things will be left to our next stage. At this stage, we want to send out a clear and simple message. Mr. Lam. Now, just to add to that, for mega construction sites or sites when workers find it hard to leave, you need to conduct a review to make sure that no worker will stealthily smoke inside. Right, next, Mr. Zhang Huigong. Thank you, Chairman. I'll try to cover my point as briefly as I can. I need to declare that I work for a construction company. Second, I support the smoking ban in construction sites. Third is a question about the OSH inspectors and the regular inspections. I suppose you will not tip off the construction site beforehand. Let's say if I want to conduct an inspection in the afternoon, I'm not going to tell you in the morning that I will be going over, right? So I'd say that these are bliss checks, which should be more effective. The next point is about public education. This is very important. I asked a question in the Electoral Council meeting about illicit cigarettes. It's a very rampant problem. Many construction workers would buy illicit cigarettes because they're cheaper. So we need the Labor Department's help. You need to enhance public education through this opportunity. Commissioner, Mr. Zhang has made a very good point. When it comes to regular inspections, it's about our work arrangements. We always conduct surprise checks for our inspections. We will not tip them off. As for publicity in education, indeed, the Labor Department does not work alone. We collaborate with other government departments and social groups, and we'll continue to make a concerted efforts. Anything to add? No. Next, Ms. Michelle Tang. Other members ask questions about the definition of construction sites and different scenarios. I will skip those. I want to express my concern about penalties. Now, the penalty should be deterrent enough. For workers, they will be fined up to $3,000. It's not really a high cost to pay. So it's just like catch me if you can, that kind of mentality. I'll just very quickly smoke a fag and you won't be able to catch me. Now, for companies, however, they will be fined up to $400,000. For small to medium-sized firms, they may not be able to afford the fine. They may go bankrupt. And also, there are many hidden corners in construction sites. It's extremely difficult for companies to introduce the relevant measures. Say if I am aggrieved, I want to punish the company, I just pay the $3,000 fine if I bring in naked light to light the cigarette, whereas the company in question will be fined $400,000. So it's a huge punishment. So is there any way to ensure fairness and prevent abuse?
Commissioner, the two questions are actually interrelated. If there are individuals deliberately smoke in construction sites to hurt their employers, that is, the contractors, we believe that won't happen. Because if they do that, they incur liability themselves. In the relevant provisions, the contractor only has to take all reasonable steps. Some members thought that might be too stringent, but we don't think so. We think as the steps only have to be reasonable, it should be within the contractor's capabilities to implement relevant measures. So the contractor should have already dealt with the possibilities. If there are workers who smoke with warning issued to them and they left a cigarette butt there, or if they take out a cigarette when inspections are being done by the Labor Department, we will definitely take the whole picture into consideration. We will consider the management measures implemented in construction sites, whether there is proper implementation of management. We won't only consider the single incident. We will take a macro perspective. But if one smokes or lights a cigarette in a construction site, they will definitely be penalized. They will be issued with the fixed penalty notice. And with the $3,000, it will be a fine no matter what background history there is, whether it's their first time or not where they are. As long as they smoke, they will be issued with a fixed penalty notice. So I think $3,000 should be deterrent enough. We will continue to review the situation in implementation. I have something to add. $3,000 is not a high penalty. For gamblers, $3,000 is nothing. So I think you should have a penalty that is at least $20,000 to increase the cost of non-compliance. Thank you. I believe the Commission notes the comment. He already explained the justifications for the relevant penalty level, so let's move on to another member, Dr. David Lam. Thank you. I think all reasonable steps is appropriate, the expression, because if we only say reasonable steps, they can just take some steps without taking other steps. I don't have a problem with that at all. I have some other questions. On exemption, we will exempt occupied domestic premises or private quarters. I want to ask if the exemption applies to those living there and their friends, or does it also cover workers? My second question is, for certain works, flammable substances are moved to the domestic premises. Would the exemption still apply? Wouldn't that be hazardous? The Commissioner said earlier there are other pieces of legislation that can be used for enforcement. Is this one of the cases this would apply? As for quarters, you said in the relevant provisions it would be private quarters. I thought it meant quarters for, say, youth hostels. But it seems from what other members said, it can be quarters for workers. So in a way, we are encouraging workers to smoke there. So I want to clarify what private quarters means. Thank you. Commissioner, regarding what Dr. Lam asked about exempted area. With exempted area, we're exempting the area. Not only those living there will be exempted, others will also be exempted. So smoking will not be illegal under this piece of legislation. But as the member said, I did say earlier, no smoking requirement is a requirement related to occupational safety and health. Say, if a worker is undertaking works in an occupied domestic premises, and the works would involve some sort of welding or flammable products, under occupational safety and health related legislation, there should not be naked lights. If they don't comply with relevant requirements, we can initiate proceedings under other occupational safety and health legislation. For works that are not hazardous, even if such works are undertaken in occupied domestic premises, the contractors still have the responsibility to take all reasonable steps. Say, if workers smoke like crazy in the premises, there is still responsibility on the part of contractors to control their workers. And if there is an additional fire risk caused by this, they should tell people there is some additional risk caused by smoking, even when the works are undertaken in occupied domestic premises. They should tell that to the workers as well as the residents. Well, what about the question on quarters, the definition of quarters? Yes, quarters. Well, as I said earlier, for temporary accommodation for employees in works projects, it may not be what we'll cover, but let me confirm that with our advisor before I give a reply to the meeting. We have some members who would like to speak for the second round, so I will extend the meeting by 15 minutes to 12:45. I'm the last one to speak. Many of my concerns are already raised by other members. With the implementation of legislative amendments, the relevant legislative amendments, members are concerned that people will inadvertently breach the law, whether there are things that are unclear. I have two major concerns. What reasonable steps contractors have to take? For example, if they have undertaken reasonable steps, they will be penalized, or even if they are penalized, it won't be at the maximum penalty level of $400,000. But what is seen as enough? For larger sites, do they have to do more in management? For example, do they have to search workers when they enter construction sites to make sure they hand over all cigarettes and lighters? Or is it the case that they will have to take photos of people smoking and make reports, just like what we do for mandatory reporting of child abuse, if they do not make such reports, will that be seen as not having taken all reasonable steps? I think in future there should be a guide on best practices. I think we should try to be exhaustive. We should do more rather than less. We should try to set out everything we can think of so that contractors will try to do everything, and if they are indeed charged in court, this can be what the court can consider. There are quite a number of members also raise concerns about how citizens may inadvertently breach the law. The Commissioner said it is unlikely going to be the case, but I think if we review the definition of construction sites, there is this possibility. There are open air spaces where a lot of people smoke, and if the area is regarded as a construction site and there are only some simple hoardings or just a few bricks to enclose the site, these may be regarded as construction materials. But then, because we have in existing legislation only laws that prohibit smoking near schools or some other facilities, not including construction sites, there are people who will smoke close to these areas. So would the contractors also have to make reports about these citizens to be seen as having taken reasonable steps? I hope with future guidelines we can make clear these different issues. About what Dr. David Lam asked, will a lot of people smoke in temporary accommodation of workers? Would that become essentially a smoking area? And if private quarters become smoking area, would that not be regarded as private quarters? Can we do something about this? Perhaps you can explore the different options you have in tackling the relevant issue. Thank you. Commissioner. Thank you, Chair. I believe guide for best practices would be useful. The sector is actually working on this, and we are communicating with the sector on this. We hope to accumulate experience first. It may be hard to use the relevant document to say whether one is doing the right thing or wrong thing, but at least it can be of reference. Let me say again that the risk of people inadvertently breaching the law is very low. We have some citizens smoking near open air construction sites. It may be convenient for them. I would urge them not to do that. They may not be within the boundaries of construction sites. While the construction sites are not enclosed, they may use bricks or water barriers to enclose the sites. But because there are specific rules in construction sites not to do something because of some sort of safety hazard, we encourage citizens not to enter construction sites. There may be a risk of smoking as well as other contraventions of the law with them entering construction sites. And there may be other works that can be quite hazardous that are being undertaken in construction sites. So we ask citizens, if they are smoking on the roadside, they should not do so close to where works are going on. Under the Smoking Public Health Ordinance, there are for specific facilities the no smoking requirement in the vicinity of such facilities such as hospitals, schools, and residential care homes for the elderly. it actually may cause more confusion for people because people may not be able to tell when we are entering a certain distance from such facilities. But I think for construction sites, it's actually very clear cut. When there are works going on, you will be able to see that it is a construction site, so citizens should not go near there and smoke there. We will provide additional guidance upon implementation of the laws. There are 3 members who would like to speak for the second round. If there are no other members who will press the request to speak button, I will draw the line here. The first is Mr. Aaron Bach. I will assign a 2-minute time limit.
Thank you, Chair. We don't want the good intention to be spoiled by the bad outcome. So I'd like to go back to the point about boundary of the construction site. Some members already asked the same question, say for mega sites covering high rises, some 30, 40 stories or even 50 stories, then in reality, some workers are bound to hide themselves and smoke somewhere. So why don't you stipulate in the law that under reasonable circumstances, an area can be designated as a smoking area for workers to smoke safely there? You can also put in place the fire blanket, fire extinguisher, and you can also stipulate that no dangerous goods should be stored nearby, so that workers will be able to smoke there. Because otherwise, workers will go out and smoke, and then in a public place there will be clashes with members of the public as they, for example, take a video footage. So can you allow the manager to designate a suitable location as a smoking area as a compromise? Commissioner. Well, very briefly, we will consider fine-tuning the proposal at the next stage. But at this stage, we want to send out a clear and simple message. That is a comprehensive smoking ban in construction sites for easy enforcement. Mr. Aaron Bach refers to the nitty-gritty of construction sites operation and that the possible nuisance cost to residents. This is something that the sector will need to work with us as well. This may not be covered by the legislation, but we'll fully consider the matter. Mr. Dennis Lam. Now, I wanted to ask a question about risk-based inspection or regular inspection. If the Commissioner has already answered the question, then there is no need to answer again. The next question is about the amendment which will take effect on the 17th of July upon passage. Now, I believe when it comes to a definition of a construction site in private domestic property, members of the public may still not be aware of the details. I don't think we can start the clause-by-clause scrutiny today anyway, so before the next meeting, please explain in writing details about the construction site and the parties involved so that we're clear about the legislative requirements. We want to protect personal safety and mitigate fire risks and avoid casualties. I just want the administration to explain better with the aid of another paper. Commissioner, thank you, Mr. Leung. That's a very good suggestion. In the future, we will illustrate the enforcement aspect through with more examples for the public, so that we're sure about the liabilities and the boundaries. Mr. Charles Chung. Thank you, Chair. I have 2 questions about the liability of contractors. The liability stems from Regulation 53 or Section 53 of the regulation. Now, is it that even with the so-called exempt area in the construction site, the liability still holds under Section 53. Second question. Now, is there a liability if the contractor fails to report somebody smoking in the construction site? Another point is I'd like the Commissioner to clarify the definition of construction site. I've sat here for 2 hours and I'm still perplexed. Say if I walk under the bamboo scaffold in the street that is not hoarded, then is it or is it not part of the construction site? If I stand there and smoke there, will I be breaching the law? Now say the whole building is now hoarded with bamboo scaffolding erected, and then there is a passageway on the ground floor, and if I walk past the pavement and then smoke, then is it or is it not a construction site? Commissioner, I'm sure you know that this happens all the time in the aged buildings in Sham Shui Po or Yau Chun Mong, where passageways are made under the bamboo scaffolds erected, and some members of the public may smoke there. First, let me answer the question on the contractor's liability. The liability is not absolved simply because of the different situations of exam area in construction sites. So this is clear. Now for the so-called passageway under the bamboo scaffold is not supposed to be a pedestrian walkway, because this is supposed to be a work location. You may recall that we have netting put up as well to avoid objects falling from height and hurting the pedestrians. So if somebody walks under the bamboo scaffolding, then it's within the area of a work site. You're exposing yourself to a real risk, let alone a fire risk if you smoke there. So the exterior wall is actually part of the construction site. And technically, if you walk under the scaffolding, then you're actually inside the construction site. But then there may not be works being carried out at the time, and at different levels of that building there may be different procedures going on. But for safety's sake, the general public should be vigilant. It's not just about avoiding being booked for smoking under the scaffolding. Where the protective netting is put up in this area to avoid object from falling, then in fact members of the public should avoid using that passageway. What about the duty to report? Now, if the contractor has taken all reasonable steps to manage the site, and that the worker is still non-compliant, and if the contractor believes that legal action should be taken to manage the non-compliant worker, then this is one of the reasonable steps that a contractor may take. Right, thank you members, thank you Commissioner and your team for coming. We've completed the policy discussion today. Members have asked questions and made comments. We've yet to begin the clause-by-clause scrutiny, but I believe that for all the questions raised, they are already very relevant to the scrutiny work. We also ask about definition of terms, and I believe that the Commissioner's explanation will be very useful to our scrutiny work as well. As for the legislative timetable, I'd like to remind members that for the two items subject to negative vetting, to allow sufficient time for the subcommittee to go through them, at the council meeting of the 17th of June, resolution will be moved to extend the scrutiny period of the two items of subsidiary legislation to the 15th of July. As for the proposed resolution, the administration has withdrawn the notice. Upon conclusion of work of this subcommittee, the administration can then give notice to the Secretariat on the proposed resolution according to the rules of procedure. Will any member propose any amendment for consideration by the subcommittee? Let me remind members that if you wish to propose an amendment, please submit the draft to the Secretariat by email before 5 p.m. on this 11th of June. If need be, we will set aside another meeting date to discuss these amendments. Now, a question for the administration. Does it intend to move the proposed resolution at the council meeting of the 15th of July? Yes, I see the answer is in the affirmative. In that case, the administration should give notice not less than 12 whole days before the council meeting. That's the 29th of June. If there is no further comment from members, then an oral report will be made to the House Committee on the work of the subcommittee on the 26th of June. As for the notice period for moving amendments to 3 items of subsidiary legislation, the deadline is the 8th of July 2026. So please note the schedule. Last item, AOB. Just to inform members, the next meeting will be held on the 16th of June 2026, Tuesday, from 4:45 to 6:45. Now we've completed the policy discussion, so at the next meeting, we're going to do something else. I hope the Commissioner for Labour can further explain and elaborate any points unclear today. And for the written views received, we do look forward to a consolidated response from the Labour Department. And then we'll start the clause-by-clause scrutiny. So please note that, members. If there are no further, Mr. Denslow, what time on the 16th? Meeting time, right? Not the notice period for amendments. Let me repeat. The next meeting will be held on the 16th of June 2026 from 4:45 to 6:45. Thank you. There being no other business, that's the end of today's meeting. Thank you.